Welcome to the Heart of Law podcast. My name is Mirena Umizaj, and I'm your host. My guest today is a good friend and client attorney I go back with over 10 years. His name is Steve New, a native of Gilbert, West Virginia, living and practicing law in Beckley, West Virginia. He graduated the West Virginia University College of Law in Morgantown in 1998. Steve focuses his practice on catastrophic cases, wrongful death cases, mass environmental damage cases, employment discrimination, and most recently, the NAS cases, Neonatal Abstinence Syndrome, or addicted babies born to addicted mothers, and also the jail cases on behalf of West Virginia inmates living in inhumane and cruel conditions. Steve has tried over 60 cases to jury verdict and has made 8 appearances before the West Virginia Supreme Court of Appeals. Of the many things Steve is proud of is the philanthropy being at the top of the list. Since 2004, and resulting from one of Steve's real-life interactions with a client, his office has given away over 12,000 bicycle helmets to children and safety groups throughout West Virginia. Personally, I have worked with Steve on many cases and legal projects, and I can say that very few people love as hard as Steve. He puts his heart and soul into every case and all of his clients. And I've been moved to tears seeing those interactions firsthand. They are family to him. So Steve, welcome to the Heart of Law. I can't believe it's taken this long for you to get on my podcast. It's really good to have you on.
Really good to be with you today, Mirena. Thank you.
Thank you so much. So I know you just came from court and rushed to make this podcast. So thank you so much. I mean, you are the definition of a trial lawyer. You go to court. Tell me a little bit about your practice.
Our practice is, as you said, it's client driven. And I've practiced law 25 years now. I've been abundantly blessed with really great clients who then feel like family or very close friends. And they're repeat customers, or they tell someone, I think Steve New and his firm should do this case for you. So we're a small 5-member, 5-attorney law firm, and we focus on certain kinds of cases. We do a lot of medical malpractice, catastrophic truck injury work, and that kind of thing. We also do the bread and butter type PI cases, car wrecks, premises liability, that kind of thing. But a few years ago, we started doing more civil rights litigation, and whether that involved law enforcement and medical care in the corrections setting. And that's led us to where we are now, which is just a humongous undertaking, taking on literally the system, the government in the state of West Virginia, for housing tens of thousands of inmates in inhumane conditions. You also mentioned the addicted babies cases. I've been working on those cases since about 2018. Those cases are my heart. I feel so sorry, and as you well know, West Virginia and Appalachia were ground zero for the opioid epidemic, and it's just horrible what's happened to my home as a result of that. So I feel like that the babies who were born addicted through no fault of their own are the most innocent victims. There are a lot of victims, and there's a lot of damage as a result of what's happened with the pharmaceutical industry. There is no more innocent victim in all of that than addicted babies. And I've put a lot of time, a lot of effort, a lot of treasure into helping try to move those cases along. I feel like the science has come to us. Now we have to try to get some judges to see what it is that we want them to see.
Yeah. And really, you just hit the two main topics that I want to discuss in more depth today, because they are, I feel like, two big wounds of society today. Addicted children, innocent children, and then, of course, the prison system, which I think everybody you've talked to will say that there is an issue, and it's long overdue, that something should have been done, needs to be done right away to fix what's going on in the prison systems, state, federal level. So we'll get to all of that. But for the audience, and which is mainly attorneys that tune into this podcast, I wanted just to give a little bit of context on the NAS cases. So the opioid case obviously had a major impact on you personally, your family, your community. You've been there seeing this from before it even was a litigation. And while everybody focused on, suing on behalf of the government entities, you focused on neonatal abstinence syndrome cases, or addicted babies, as we say. These cases clearly are near and dear to your heart because, again, everybody was saying, no, don't take plaintiffs. And you were, at least in my knowledge, from my network, the only person I know that was. And you've worked on this case for some time, spent a lot of your time and resources, and it's been quite the roller coaster. For the audience, these are babies exposed to opioid use in utero, suffering with a multitude of health issues that range from physical defects all the way to severe mental health issues, ADHD. And according to Centers for Disease Control and Prevention, one baby is diagnosed with NAS every 24 minutes. That's 59 newborns diagnosed in the United States every year, every day. I'm sorry, that's every day. The number of babies born with NAS increased by 82% between 2010 to 2017. And these increases were seen for nearly all states and demographic groups. So do you think the legal strategy that was pursued in opioids didn't include the opioid victims on purpose? Like, was there a multi-layer strategy? Like, what happened? Why weren't these babies represented?
Well, I think that their theories for the governmental entities were so different than theories that we're trying to pursue. The theories that we're trying to pursue don't lend themselves to class treatment. They do lend themselves to mass treatment, but because each baby may be affected so differently, or because the array of what the mother may have ingested while she was pregnant may be so different, it's a very individualized process to bring that case. When you sue on behalf of the city of Huntington, West Virginia, and Cabell County, you're talking about one geographic area there, and how many people live or lived in that area over the period of time that drugs were coming in. What our cases are highly individualized, highly specific, and you have to really understand how did the mother become addicted? Did she start with street drugs, or was this a legitimate prescription? And then you trace that back, and you have to figure out, well, what was going on with that drug company right at that time? Were they trying to boost sales of opioids? Were they marketing to pregnant women? Was that a part of their marketing strategy at the time that this baby was born? So, I'm not casting any aspersions to anybody. It's just what the governments had to prove their nuisance cases, and what addicted babies have to prove are two totally different things. And then you have a couple of extra steps and a couple of extra entities with the counties and the cities and the states. It's the distributors, the manufacturers, the pharmacies that distribute that stuff, and then it gets in the public as a nuisance. And between our babies and the pharmacy that may have filled an opioid prescription, you have a doctor that wrote the prescription, and you had a mother who consumed that opioid. So they're complicating factors to addicted baby cases that are just a little bit different than the governmental entity cases, Mirena. And so for that reason, it's a very highly specific undertaking to represent these children.
But my question is, when the legal teams were formed to represent the entities, was there ever a conversation that this piece would also be addressed? Or did it just kind of fall through the crack? I mean, like, what happened that didn't give these babies a chance?
I believe that our cases were, because of the highly specialized nature, and there wasn't a class certified in the 2804 MDL, our cases then had to await the resolution of other stakeholders' cases, the governmental entities, hospitals, third-party payers and insurance companies, Native American tribes. And it was kind of like our babies' cases were at the back of the line awaiting the resolution of those cases. I wasn't privy to those conversations. I don't know if that was, on purpose, or if that's just the way things went when there was a denial of class certification in the 2804 MDL. So what my team and I decided to do then is to take a state by state approach, which is also proven difficult. But as I said, the science has come to us in the 5 years that we've been doing these cases, I think in part because of the opioid litigation that was pursued and some of the things that have been going on. Certainly the CDC has been more helpful, and some of the research. So the science has actually come to us, whereas before in 2018, 2019, 2020, there were still all of these questions about, could you link the mother's ingestion to the specific problems that the baby was having? And as we've seen in the 3 years since, the science is actually supporting us.
So how many babies do you represent?
Individually, I represent 440. I am a part of a collective where we represent about 3,500 babies.
Wow. And what are some of the birth defects or mental health issues or just the physical challenges these children are facing?
These children face typically the birth defects, the physical birth defects that you see are cleft palate and club foot, as well as what's called a Chiari malformation of the skull and the spine. And then on the mental, emotional side of things, these children, it takes a while to know that they are developmentally delayed. And when they stop reaching those benchmarks at 18 months, 24 months, 36 months, then that's when adoptive parents or grandparents start to try to put the pieces together, what's going on. And then by the time that the child is about between the ages of 5 to 7 or starting school, you really start to see the effects of mother's consumption of opioids in utero if the child can't meet those benchmarks. And you also start to see the development of emotional behavioral problems, attention deficit disorder. It is rampant in my clients, and a lot of it has to be dealt with by people like grandparents or an aunt and uncle who maybe weren't perhaps prepared to become parents again, and they need resources and they need help for how to deal with what is essentially, or what may be, a special needs child at that point.
So I'm assuming you're talking to families on an ongoing basis. Are there any resources government, private? Where do these families go for help?
Well, in a state like mine in West Virginia, we have a program here called Birth to Three, and it's run through the state's DHHR. And if there's an adoption through DHHR, automatically that Birth to Three is set up. But for all parents in West Virginia, that Birth to Three program is available to help with a child. Where it gets difficult, Mirena, is between the ages of 3 and 5 when the child typically starts school. Yeah. That's a period of time when the child needs the most work because of child development, but there is no safety net between ages 3 and 5. You don't have the schools and what a school might be able to do in terms of an individualized education program, access to social workers, things like that, and the Birth to Three program in West Virginia. So it can be very dicey for these parents. And what we're seeing also is just access to quality health care. In a state like West Virginia, I represent a number of West Virginia babies where there may be only 3 pediatric neurologists in the entirety of the state. And so if they're on West Virginia Medicaid, they must treat with a physician in state. It's not like, even though the University of Virginia is only about 2.5 hours from here, they can't very well go to UVA and get treatment because West Virginia Medicaid won't pay for that. So there may be in the entirety of the state only 3 pediatric neurologists that these children could have access to. And that may be as far away as Morgantown, which could be in up to a 4-hour drive for some of these adoptive parents or grandparents. So it's multiple layers of barriers to care and issues that we're trying to seek redress for.
Right. Do you know what percentage of these children have ended up in foster care? Is that information?
Virginia, about 65% of all of our children are being raised by someone other than their birth parents.
Wow.
Yes, and it's gotten worse through the years as the opioid epidemic has dragged on and gone on. At almost 2 out of every 3 children born in the state of West Virginia are being raised by someone other than a birth parent. And in some counties down in the southern part of the state where I am here, that number can be as high as 75 or 80%.
That's just unbelievable. Heartbreaking.
Yes.
So Big Pharma obviously had a big part of why this happened. They were marketing to mothers that it was safe to use opioids during pregnancy. Tell me about your legal approach to these cases, and what is the premise of the legal action, and what is the current status today?
Well, the current status is all over the board, really. We're still stayed in the 2804 MDL, and we took an approach in my home state of West Virginia. We had a very large array of distributors, manufacturers, and both national and local pharmacies. Some of the attorneys, not part of my group, brought a private nuisance theory on behalf of these children. Our theory was on a failure to warn, more of a products liability type. You've placed an unsafe product into the stream of commerce and you failed to adequately warn. When your drug rep said this was safe for mom to consume while pregnant, that you knew that wasn't true, or that you should have known that your warning was inadequate. And those are the primary thrusts from the legal counts. We also alleged that there was a conspiracy because we thought that all of these entities wanted to see the opioids continue to flow to pregnant mothers. The manufacturers, along with some consulting firms, decided that they would treat pregnancy pain or not require pregnancy test before prescribing an opioid, and that was a deliberate decision. We have evidence in this case that Big Pharma knew just how much of the market would be lost if they went with a like what you hear on the TV commercials. Don't consume drug X if you are pregnant or expect to become pregnant or are nursing. I mean, our position all along has been very simple. Put that kind of warning on an opioid. A mother, let the mother, if she has pregnancy pain, if she has residual pain from a trauma, a car wreck, or an on-the-job injury or something prior to becoming pregnant, let mother change to something that's non-addictive while she's pregnant. And Big Pharma knew that. They didn't want to lose that segment of the market, Mirena.
Obviously, you took this to court. Can you share a little bit about what happened?
Sure. In West Virginia, the judges summarily granted a 12B6, a motion to dismiss, and we had maneuvered the cases to the West Virginia Mass Litigation Panel. The Mass Litigation Panel had resolved the governmental litigation in the state of West Virginia, as West Virginia opted out of the national settlements and that kind of thing. And that case is on appeal right now, so I'll be a little bit limited about what I say, but we obviously believe that many of the things that the court decided on the motion to dismiss are things that historically the case law has said should be decided by a jury. We should go through the discovery process to find out who knew what and when. And in that order, the Mass Litigation Panel said that the sole proximate cause of the baby's addiction was the birth mother's. And we just thought that was a horrible ruling, both because it was decided at the stage that it was without the benefit of discovery. I feel like that the Mass Litigation Panel would need to know these mothers' stories. The story of our lead plaintiff. She was in a car wreck, a really severe car wreck in 2011. Her physician kept upping her opioids. At one point between 2011 and 2014, she was prescribed 3 different kinds of opioids to treat her many pains. And then her child was born in early 2017, and he was born addicted. I think that the Mass Litigation Panel needed to hear that story as it would be told through discovery in order to have the entire picture, and also for us to be able to get the documents from Big Pharma and to know who all was talking to whom, what information were they sharing about that portion of the market. And I believe if we get a chance to go through discovery in that case, I believe that it will be very telling.
What do you think? How do you think the appeal will go? I mean, I know you don't have a crystal ball, but what does your instinct tell you? Because if it doesn't go well, there's no recourse for these children. I just can't comprehend that.
Right. The only thing that I can say is that if the Intermediate Court and the West Virginia Supreme Court of Appeals rule the way that courts have ruled for about 100 years in the state of West Virginia, which is that those things, causation, those type things get decided by a jury. They don't get decided by judges. Then I think that we should be okay.
Yeah.
Big if, though.
Listen, you're fighting, such an important fight. So I really hope that there is some coming to Jesus moments for these judges, because these children need help. And the state of West Virginia has been hit the hardest. And Big Pharma should be held liable. I mean, if anybody knows what addiction means, right, it's not a voluntary action. So holding somebody accountable for a voluntary action is criminal, I think.
Right.
Involuntary action, I should say. So, all right. You'll keep us posted on that, and hopefully we have some good news to
Love
share.
to come back and visit with you a number of months down the road when hopefully West Virginia gets reversed and we're back in front of the mass litigation panel and in the discovery process. And I will also tell you that our group is looking at 2 to 3 other states right now with different kinds of laws that we believe will be favorable to these children, New York, Tennessee, Louisiana. And I do look forward in getting started in those states as well and seeing where it goes, because the cause is so worthwhile, Mirena. I can't tell you enough how worthwhile the cause is. If you've ever gone to a NICU and you've ever seen one of these children shake in that withdrawal, you know that this case is worthwhile. And you also know, if you study the science, that the residual effects aren't over when you detox the baby. The baby can spend 4 or 6 weeks in a NICU and being detoxed, but the effects of that are felt for much longer than previously believed. So I look forward to continuing this. You know, people say I'm crazy for being the patron saint of lost causes, but no cause is truly lost if you fight the good fight and you're in there swinging just as long as you can manage to stay swinging, because at some point, some court is going to hear the voices of these children and care.
Yeah. I really do hope that that's the case. And again, I just have so much love and respect for you for doing what you do, because you are a small firm in Beckley, West Virginia, taking on such a monumental cause. I know that you're working with other firms as well, but to represent over 400 babies and to listen to those stories and to continue forward, defeat after defeat is commendable. And I truly, truly respect you. And thank you for that. As if this is not heavy enough, you decided to take on another monumental fight. And I'd love for you to tell the story of how you got roped in on these cases. But the jail cases is another project that you're working on and you're knee deep in. I was sort of in disbelief when you told me you were taking this on, because I'm thinking, Steve, you've got so much on your plate. What are you doing right now? Right. But then hearing you talk about why and the injustice, violating constitutional rights, and just hearing the sort of the background, how you got here, again, just another layer of deep respect. Can you share a little bit about how these cases came to you?
Sure. My firm traditionally has done civil work, no criminal work. My firm is on a mandatory appointments list here in Raleigh County, West Virginia. But typically, Mandy and I and the other attorneys have represented children or parents in like a child abuse and neglect type case. We haven't done criminal work. So in early 2022, I read this story about a judge in McDowell County, West Virginia, who had ordered the Commissioner of Corrections down to his court because there was a young lady who had only been in the custody of the Division of Corrections for about 3 or 4 days. And you could look at her mugshot at booking. There's no problems. And 3 days later, she's completely beaten. So the judge has questions. Why is this young lady, when she shows up for her first court appearance, beaten up? She's only been in your custody 3 or 4 days. And so that sort of started this ball rolling. Then here in the town where we live, there's a jail called the Southern Regional Jail. West Virginia has 10 regional jails, 10 prisons. and 10 juvenile facilities, 30 facilities total. And in March of 2022, a young African-American man was beaten to death by 2 guards with, I believe, the assistance of other guards at the Southern Regional Jail. His name was Quantez Burks, and his family lives here in Beckley. And immediately you could tell that the cover-up was starting to go on. The government wasn't answering questions about what had happened to Mr. Burks after being apprehended here in Beckley, taken out to the Southern Regional Jail, and ending up dead within hours. And we get a call at that point here at the office from one of the guards out there, one of the correctional officers, who was being targeted for termination. And what we realized in representing him was that he and a few of the other guards had been trying to blow the whistle on some of the things out there at the Southern Regional Jail, from the beatings to the deaths to the horrible conditions to the fact that the inmates didn't have food or clothing, that the jail was originally built to house about 280 inmates, and the jail has had upwards of 700-800 inmates in it through the years. So we get this whistleblower case. A friend of ours gets the case where the young lady was beaten up, and another law firm gets the Quantez Burks death case, and we all start comparing notes. We all start going, what is going on out there at the Southern Regional? And we realize this is a systemic problem. That jail is overcrowded by about 3 times. They are understaffed because they work their people in such horrible conditions that they can't keep correctional officers and other staff members. Through the course of 2022, there were 13 inmate deaths at the Southern Regional Jail. One regional jail in Beckley, West Virginia had 13 inmate deaths, either resulting from beatings from guards, beatings from fellow inmates because there aren't enough guards, or inadequate medical care where people were complaining, I have some issue going on with me, and either the jail itself or their medical company contractor just ignored those complaints. So we started getting involved in June, July of last year. We filed the suit in September of 2022. And I'm pleased to say that we have now filed a class certification motion on behalf of the 17,000 inmates who have gone through that jail from September of 2020 forward. And that case has gone very well for us. Every deposition has gone fantastic. We've uncovered a lot of just horrible things out there. And in mid-June, we brought in a number of expert witnesses who were able to confirm that the conditions were awful, that the water is bad, that the air quality is bad, that the maintenance has not been done. And Mirena, what we were able to discover is that West Virginia has about 30 correctional facilities, prisons, jails, juvenile facilities. West Virginia has let its maintenance go in those facilities to the point where they have $277 million in deferred maintenance at all 30 of those facilities, which averages out to about $9 million of maintenance that needs to be done. Cell doors don't lock, and toilets don't work. Showers don't work. Inmates don't have mattresses. They're sleeping on floors. There will be sometimes upwards of 4 to 5 inmates in a 2-person cell. It's the worst conditions that you can possibly imagine. Just inhumane. No human being should be subjected to those types of conditions.
Animal for that reason.
Right. No animal should be housed. People would be up in arms if we found out that animals were being treated the way that these animals have been treated. And it's gone on for about a decade. We have figured out the Southern Regional Jail has been overcrowded to one extent or another since 2005.
So when you say they're deferring maintenance, what's the logic behind that? How do you defer maintenance, and why?
How you defer maintenance is that the Division of Corrections goes to the governor and to the legislature and says, our facilities need $30 million worth of maintenance this year. And the legislature and the governor allocate $2.25 million year in and year out, when upwards of $8, $9, $10 million may need to be spent. Well, eventually that catches up with you.
Right.
And the reason for it is simple, Mirena. Prisoners don't vote. They are not a sympathetic constituency. So it's easy in good years when you have budget surpluses to say, oh, well, that's just inmates. We'll get around to that eventually. And then when the years are lean in the budget, well, we don't have the money for it this year, guys. Sorry, you need $10 million to do maintenance this year. We're only going to give you the $2.25 million that we've been allocating for you. And eventually those chickens come home to roost.
Right. Yeah, you'd mentioned to me that the state of West Virginia, I don't know if it was the state of West Virginia or maybe a particular area in West Virginia that had a budget surplus. And so have you had some of those conversations to say, wait a second, we've got budget surplus, but we can't provide the basic needs for these inmates?
In fact, in addition to the Southern Regional Jail case that we started last September, a few weeks ago, we sued the governor of the state of West Virginia and the secretary of the Department of Homeland Security. Mm-hmm. And I took evidence that we had gathered from the Southern Regional Jail case and testimony from the Southern Regional Jail case, and I used that as the basis for the statewide injunction against the governor and the secretary of Homeland Security, where their own people had said, we need $277 million for deferred maintenance. We need $50 to $60 million to correct the understaffing issues in the state of West Virginia. So we brought a few weeks ago a $330 million injunction against the governor of the state of West Virginia to say, Judge, these problems need fixed, and they need fixed right now.
Wow. What was the reaction from the judge?
Well, we haven't gone to court yet. The defendants answer November 6th, and then we will have hearings on that. But we are asking the judge to prohibit the state of West Virginia and the governor of the state of West Virginia from housing inmates in unconstitutional conditions. But it got a lot of press coverage, and we have started to turn the tide in the state of West Virginia from the perception of these cases. At first, you would hear a lot of, oh, well, prison can't be hard enough. These are bad people. They've committed bad acts. We've really seen public sentiment kind of turn and say, you know, that stuff's awful. Nobody should die because they commit a $37 shoplifting violation.
What about, obviously this issue is very relevant in other places in the country. I would argue in every state of the country. So mental health, for example, I would also say, not that I have any exact findings, but a lot of these people need mental health care. And I don't know that they're getting it. And then whoever is being released, being released and there is no programs that integrate these people back to society. So you have, a new set of victims that, you add to sort of the equation every year. This is such a big, large issue. What are you trying to accomplish by starting this in West Virginia? What's the big picture long term?
Here's the big picture. The former commissioner of the state of West Virginia, she testified that because she couldn't get maintenance done, she couldn't keep enough officers, her jails were overcrowded, that she never could get to the rehabilitation parts and the programs that she really wanted to do, the GED programs, the drug rehab programs, the reintegration into society, the job intern programs, the case record expungement programs that she wanted to do. But Mirena, if you don't have enough guards to guard the doors, if you're putting secretaries on guard posts, you can't focus on things like helping inmates get their GEDs, helping inmates enter into drug rehab programs. And let's talk about drugs for just a moment. West Virginia has actually done studies on that. About 75% of all inmates entering West Virginia's facilities have some type of drug addiction issue.
Right. So it's all related.
It's all connected. Now, what I would like to do is this. Once we win the Southern Regional Jail case, and once we get the injunction, and we're already starting to have some success, the state of West Virginia allocated $25 million for officer salaries. That's about half of what was needed, but at least it's a start. And West Virginia also, in a special session in August, allocated $100 million to corrections to catch up on deferred maintenance. So we're about halfway there to what we need to accomplish for that. And if the state of West Virginia does what it says that it's going to do, or we accomplish a settlement to say that West Virginia, out of a $1.8 billion budget surplus, will allocate the other $180 million, then we will be at mission accomplished in the state of West Virginia, and West Virginia can start focusing on some of those inmate programs to help these inmates when they transition out of jail. And my goal then would be to go to other states where I know that the conditions are just as bad, Kentucky, South Carolina, Louisiana, New York, Texas. And at that point, we know where the failures are. We know what needs to be done to fix that. And also on the federal level, there are 120 federal correctional facilities in the United States of America. If you take the 7 or 8 in the state of West Virginia as a cross section, it's awful. And I would actually like to be able to bring an MDL in the state of West Virginia, but a multi-district litigation against the Bureau of Prisons. That's right. The big picture.
The big picture. Obviously, this is not a very sexy case, right? I have talked to many law firms about this because I just think, obviously, it's an important cause, and it doesn't move a lot of people, right? It's one of those things. It's like, the attorney fees would be capped, or this is not the right group of people. There's so many misconceptions. So how do you get people to action and across this nation for this to catch fire? Because prison reform is long overdue and everybody's been kicking the can down the road. How do we bring attention and awareness to this cause?
I think that you start with the stories, because the 37-year-old mother who was brought in on a shoplifting charge, who was assaulted by fellow female inmates thinking that she had drugs smuggled into her person, and she died 2 weeks later, leaving behind an 11-year-old. It's those stories. It's the Quantes Burke's story. It's the stories by stories where you start to change the hearts and the minds of people. And then lawyers need to stop looking for the easy case, because if you think about whatever kind of mass tort that's ever been done, you might have thought that it was easy. It didn't end up being easy. 3M, congratulations, wasn't easy. PFAS, not easy. Roundup, not easy. Now, you eventually get to where you want to get to, but the birthing pains are significant for that. It's the same exact thing here, because you just have to understand, if you prevail in a 1983 claim, a civil rights claim, you get awarded your attorney's fees. So there are some limitations because you're suing governments and you aren't suing big corporations like in most of our mass torts that we deal with. But in a lot of cases, Mirena, contractors are involved here. Private companies are involved, and they have insurance. Like the medical contractors in our cases that we're dealing with here have huge insurance policies. They have primary policies, and then they have $50 million excess policies that can be triggered. So if you're finding a pattern of deliberate indifference relative to medical, well, those are very large corporations, and they have very large insurance policies. But I think to change the hearts and the minds, I think to some of my fellow attorneys, even guys like me who haven't done criminal work, I think once they understand the nature of these 1983 civil rights claims, will say, I think a light bulb will go off and say, hey, this is a systemic problem. And if we could attack the BOP, the Federal Bureau of Prisons, in an MDL, and then we could go from state by state by state by state, following this playbook, doing the things that need to be done to change the conditions, to make sure that inmates aren't being incarcerated longer than they should, that their rights to rehabilitation are being seen about, then I think there is a chance here to build this as a practice group in in the United States of America, not just West Virginia, where attorneys can say, hey, I want to do some of that work. I believe that work is worthwhile.
Gosh, there's just, as you're talking, I can't even catch my first thought because there's so many rushing. But I'm thinking as I hear you talk, that because everything is connected, drug use with prison, like numbers in overcrowded prisons, you've got somebody serving 5 years with somebody that's serving a life sentence. How is that person serving 5 years going to escape, right? Most of those people end up committing other crimes just to stay alive, right? And they never get out of the system, right?
Right.
So I just find it that the entire thing needs to be wiped out. Like these vendors need to be bankrupt. These rehabilitation programs. I mean, I was actually part of a meditation community, and actually this happened just this past 2 weeks. And very randomly, we were talking about how just bringing in people who were teaching inmates to meditate was changing the entire energy in a facility. And instead of being at each other's throats, they were meditating 30 minutes a day, and they were nicer. Even the guards were meditating with them. This is in Mexico, by the way. Now they're going to bring some of these programs into America. But I'm thinking something as simple as that, or taking the models from other countries, right? We're not all the same, but we're people, we're humans, right? And most of these people that are incarcerated come from horrible conditions to begin with. Not everybody is born evil. And so how do we heal a society if we're not taking care of the people that need the most help, need the most assistance? And something as basic as meditation could totally turn this thing around. So do you think this could catch fire? Do you think the momentum is right? What needs to happen for this to really become a movement?
I think that I need some other attorneys in some other states who want to do this, who either have the firms and the firepower in terms of lawyers to help with it. There have been 7 of us in West Virginia do this. 7 lawyers working together have managed to do this. I just imagine if I had 10 lawyers at my direction in each state, what would we be able to do? We'd be able to do a lot of really good things. But I think that some lawyers who haven't typically done civil rights work are going to have to decide, yeah, I want to help with some of that kind of work, even if that's not been what I've done or my firm has done in the past. And we're going to bring some work to it, along with some combined expertise about some things that are going on. And then there also has to be some outreach. I've worked with the ACLU and the Nation of Islam thus far, and there needs to be some networking of people who want and groups that want to do prison reform, all moving and rowing in the same direction, and willing to set the agendas to the side or anything like that. Because really the only agenda is, how do we improve conditions? How do we get America broken off of we got to be tough on crime? We incarcerate more people than the whole rest of the world. And we're the United States of America. And we're the laughing stock on certain issues like guns and incarceration and other things. And we ought not be. But for this one particular issue, corrections and correctional facilities, we have a chance right now to reverse this.
Yeah. So can you walk me through, I'm the non-lawyer in this podcast. So walk me through the legal strategy in the MDL, and assuming that there is a recovery, where does that money go and how is it, right? So who is going to benefit from the recovery?
Well, the strategy would be with the United States government, you have to file what's called a Form 95. It is the form, it's a governmental form that has to be given to the United States government 6 months in advance. And so what would have to happen in an MDL is for clients that notify the offices, you would have to have them complete their Form 95 and describe the unconstitutional conditions that they believe they're exposed to. For the 7 or 8 federal facilities in the state of West Virginia, we've already done that. And we know what we believe the unconstitutional conditions are in each of the 8 federal BOP facilities. What will happen then is the United States government is going to have a decision to make about how it wants to handle that. And you can't do a class action against the United States government, but so you would have to figure out a way to do mass filings from across enough jurisdictions to get an MDL established, and then you come up with that plan for how to litigate those cases, figure out how many inmates are we talking about, and then it may take some type of a prison reform bill on Capitol Hill to say, all right, we're going to compensate prisoners who have gone through or been in federal prisons for X number of years, and we're going to allocate this much money to correct those conditions.
Okay, so no money would be going under this scenario, would be going to the inmate directly.
It would. That they would be compensated, but there would also need to be a piece of it on the injunctive relief to actually fix the conditions. The inmates, the prior inmates would absolutely have to be compensated. Yeah.
So I'm thinking, instead of, because obviously it's going to be hard for a jury to award money, no matter how horrible the crimes are, or it would just be sort of an unfair comp to an inmate versus somebody else sustaining that injury that's not an inmate. What if there is, the money goes into the programs to rehabilitate them instead, right? Instead of just giving them the recovery directly. I mean, if we're dealing with most of them being drug addicts and, related to gangs, that obviously may not be ideal, but something that truly allows them a path out of the prison system, integrate them back into society, and potentially a fund for any future victims that are victimized by those people that are released.
I mean, I think as much as you want to think outside the box in terms of compensation, I think as long as the judge and whatever guardian ad litem gets appointed for the inmates, because they are protected people, they are in the state's custody, I think that so long as the judge blesses off on those types of non-traditional compensations, I think everything would be on the board at that point, Mirena.
Yeah. Wow. Well, I used to have a different perspective about mass torts and the reason why the MDL world has sort of sucked me in is because I have seen firsthand the impact, when done right, the impact it has on large segments of the population. I do believe that both the NAS cases and the inmate cases are worthy of attention and love and fighting for justice. I think if we could give those people a chance, then we can only go up from there as a society. And when you look at the firms that have worked on what I now consider really large MDLs that are super successful, they were very small firms like yours. This is, one or two people in small towns that came across that case that became very passionate. And of course, the NEC, the baby formula cases is one that comes to mind in Connecticut, and the Camp Lejeune that comes to mind that, I've been working on for the past 3 years. So nothing is impossible as far as I'm concerned. And you have that approach to justice, you have that vision. So I do hope that the right people are, resonate with what they're hearing and they come to you. What would be the best way to get in contact with you and to make sure that we continue this conversation?
Sure. They can call me at the office at 304-250-6017. Reach out by email, steve@newlawoffice.com, and just have a conversation. I'm having conversations with attorneys in Louisiana, in Kentucky, in Georgia, as we speak. Those conversations are ongoing. Now, they're a little timid at this point because they want to see what happens in West Virginia. But they're like, man, if you get that class certified, we need to get rolling because I've got X number of criminal clients and they're in these horrible conditions. And I'm like, yeah, guys, I read the papers. I know that the conditions are awful everywhere. But if someone just wants to contact me at my office, Mirena, then I can have a more in-depth conversation about what we're doing here and what we hope to do in the future.
What? Tell me a little bit briefly about the class certification. When did you say you expect that to go in front of a judge?
In October, mid-October, October 17th, I believe, will be the hearing on class certification. And all of the discovery on class cert is done. We're wrapping up some other non-class discovery. I'll hopefully get to depose the governor of the state of West Virginia in a few weeks. And then we'll see where class certification goes in October.
Well, that's going to be another one that we may need to talk about next time that you're on. Again, I truly appreciate everything that you do. I have the utmost respect for you, and I'm behind you, and I will do from my position everything I can to support with these causes and the network that I have. So hopefully we can come back to the audience with some great updates Thank you for your time, and keep up the good fight.
I love you. I love your passion. I love what you do, the services that you provide for attorneys like myself, huge law firms, smaller law firms, everywhere in between. Ever since I met you, 10 or 12 years ago, you've been such a great friend. You've had my best interests at heart. I love working with you, and I can't say thank you enough to you. Thank you for having me.
Thank you so much. Thank you. Thank you, Steve.
Stay tuned for upcoming episodes available on popular platforms such as iTunes, Spotify, and YouTube.